Good morning, everyone, and thank you for joining us for the Medical Board of California Panel A interim meeting. Pursuant to SB 189, this meeting is being conducted via WebEx. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click on the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will still allow you to hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the WebEx agenda for step-by-step instructions, including screenshots. Thank you, Ms. Lubiano. We can now start the meeting.
Great, thank you. I'm going to turn my camera on here. And sorry for my noisy office mate that I have here. Let's see. Okay.
Excuse me, Your Honor. Excuse
Oh.
me, Your Honor.
Yes, Ms. Temple.
Yes, ma'am. Are we on the record?
No, I'll make sure I tell you. I'll check with you to
Okay.
make sure you're ready, and then I'll tell you when we're on the record, and then I'll tell you when we're off the record. So,
Thank you, Your Honor.
yes. Please continue, Ms. Lubiano.
Thank you. Welcome to the January 4 meeting of the Medical Board of California. This is Panel A. My name is Lori Rose Lubiano, your chair for this meeting. The first item on the agenda is a call to order and establishment of quorum. I'll turn it to Ms. Jaramillo to call roll.
Sure. Dr. Bola?
Here.
Dr. Hawkins?
Here.
Mr. Rue? Dr. Tsai? Mr. Watkins?
Yeah.
Ms. Lubiano?
Here, thank you.
Okay, we have a quorum.
The second item on the agenda is the oral argument following remand for Dr. BADII. I will now turn it over to our administrative law judge, Judge Larson.
All right, Dr. Betty, are you with us? See his name. I also see Mr. Firestone.
Yes, I am here. I
All
am
right.
here.
And I see Mr. Firestone. You can hear me, yes?
Dr. BADII.
Dr. BADII, hello, I see you. Mr. Firestone, can you hear me? This is Judge Larson. I am not hearing.
I can hear you, Your Honor.
Okay, there we go. And then I see Greg Chambers, and that is our Deputy Attorney General. Is that correct?
Correct.
All right, then everyone is here, yes? All right. All right, so in just a moment, we're going to go on the record. I will announce the matter. I will have counsel announce themselves for the record, and I will also have our panel members announce themselves for the record as well, since we'll be on the record with our court reporter. And then I'll briefly explain how the oral argument will proceed this morning. All right, as soon as our court reporter tells me she is ready, we will get started.
I am ready, Your Honor. Thank you.
On the record. All right, good morning. We are on the record before the Medical Board of California, Panel A, in the matter of the first amended accusation against Robot's body.
I'm sorry, Your Honor. You're glitchy.
Oh. Okay, where did you lose me?
Well, we are on the record in the matter, and then you got glitchy, Your Honor. Thank you.
Okay, let's try that again. All right. All right, good morning. We are on the record before the Medical Board of California, Panel A, in the matter of the first amended accusation against Robot Body, MD. This is Medical Board case number 800-2020-068-036, OAH case number 2022-1040. Today is January 4th, 2023. It's approximately 10:11 a.m. This is the date, time, and place for oral argument and the notice of oral argument in this matter. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this hearing. I'm going to please have the board members identify themselves for the record, starting with our chair.
Good morning, Lori Rose Lubiano here, Chair of Panel A.
And Mr. Hawkins?
Good morning,
sorry.
Dr. Randy Hawkins, Vice Chair.
And Dr. Bullitt?
Hi, good morning. Dr. Michelle Bolott, member
And
of the medical.
Mr. Watkins.
Good morning, Ezric T.J. Watkins.
And we do have a quorum present. May I please have the appearance of the Deputy Attorney General
Greg Chambers with the Attorney General's Office, Your Honor.
and counsel for respondent.
Marvin Firestone here.
All right, good morning.
Good morning.
And we also have Dr. Baldi here, correct, as well.
Here.
All right. So the board in this matter has issued an order fixing date for written and oral argument after Superior Court remand. The board has invited particular discussion of how the board's disciplinary order should be modified in light of the court's decision. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. Respondent will then have 5 minutes for closing argument, and the Deputy Attorney General will have 5 minutes for closing argument. These time limits will be strictly enforced. I will do my best to inform you when you have 1 minute remaining with regards to the opening and closing arguments. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. Panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Myself and any panel member may ask a party to support the party's oral argument on a matter with specific citation to the record. At the end of oral arguments by counsel, I will offer the respondent an opportunity to address the panel regarding the penalty. If the respondent elects to do so, I will first place him under oath. After oral argument today, and there's 2 oral arguments, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive a decision sometime in the future. Please remember that all arguments must be based on the existing record and no new evidence will be heard. And also please remember that the board panel members have already had the benefit of reading your briefs. All right, any questions before we get started?
Your Honor, it's Greg Chambers from the Attorney General's Office. It would appear
Yes.
that the licensee intends to present a PowerPoint presentation, which we believe is outside of the parameters of the order fixing date for written and oral argument. Pursuant to that order, the parties are limited to what they can present pursuant to the California Code of Regulations 1364.30 and 1364.32, which define the written argument and the oral argument. And it would appear that licensee is attempting to combine the two with a second bite of the apple here, and we would object to that.
All right, so any response, Mr. Firestone?
Yes, Your Honor. The slides, the PowerPoint slides are essentially just derivatives from the record itself, and essentially as a courtesy to the medical board members in order to follow the presentation.
We got approval
Right, so based on
We had contacted Ms. Jeremiah well before to get approval to provide these slides.
prior.
All right, so did you submit this in advance to the Deputy Attorney General?
Yes.
We did.
I have not received a copy of these, Your Honor.
We sent it to, I believe, James X. Hyman, as I recall.
And as you're aware, Jane Zach Simon retired in
so-
June.
Okay, Mr. Chambers, I don't need you to respond unless I asked you to do so. So this is not provided for, so you were able to provide a written brief, which you did so, and now you're able to provide oral argument, so I'm not going to allow the PowerPoint. So if you would please stop the share on that, and then let me know, please, when you are ready, and I will start your 15 minutes, Mr. Firestone. Please tell me when you're ready.
I'm trying to stop the share, Your Honor.
Okay,
I've gone ahead and done that. Mr. Firestone, yeah, you're clear to proceed.
Okay, thank you.
Are you ready?
I'm ready, Your Honor.
You may begin.
Thank you, Your Honor. Members of the medical board, Dr. BADII, and counsel, good morning. My name is Marvin Firestone, and it's my honor and privilege to represent Dr. Roozbeh BADII before you today to present the evidence and the law in this matter. This hearing before you is a result of the Superior Court remanding this case back to the board because it determined that the proposed decision of the administrative law judge to revoke Dr. BADII's license to practice medicine was an abuse of discretion. At the end of the presentation, I will be asking the board to dismiss the pending accusation that's been filed, or at most order a public letter of reprimand in this matter. First of all, I'd like you to recognize that the issue here is whether or not Dr. BADII is a danger to the public. And the evidence that I'll be presenting will support the fact that Dr. BADII is not a danger to the public. Most, if not all, of the evidence that I'm going to present was testimony by the medical board's own expert witness, Dr. Nicholas BADII, who was the only medical expert to testify at the hearing. Dr. BADII did not believe that he needed his own expert because Dr. BADII's evaluation and opinions supported the dismissal of the accusation. Dr. BADII, in his report, found, and it's found in the administrative record in Exhibit 7, he unequivocally concluded that Dr. BADII could continue to practice medicine. There were no allegations of improper patient care nor breach of the standard of care. The board's required to take disciplinary action that's calculated to aid in the rehabilitation of the physician whenever possible. This is spelled out in Business and Professions Code Section 2229. The evidence that we have submitted supports that Dr. BADII can safely practice without any restrictions or conditions. And you'll see that in Dr. BADII's report in the administrative record, Exhibit 7, A136. Let me give you a little bit of background of Dr. Roozbeh BADII, MD. Dr. BADII is a well-trained and highly skilled board-certified internist. He holds licenses in multiple states, including New York, Connecticut, Indiana, California, and Michigan. Why does he have so many licenses? Because once the COVID pandemic hit, he reverted to doing his treatment via telemedicine, and the doctor is required to have a license where the patient exist, and he was seeing patients by telemedicine in several states. Prior to that, he was a hospitalist and received several awards for his work as a hospitalist. You can see that in his curriculum vitae in the administrative record, Exhibit A. So why did Dr. BADII have to appeal his revocation of his decision that was made by the administrative law judge and adopted by the medical board? Fact is that Dr. BADII does have a mental health history. Dr. BADII suffers from a mood disorder. It's called seasonal affective disorder, which means that when the weather becomes rainy or overcast or cold in some way with the overcast, Dr. BADII has symptoms of depression, at which time he has learned to take that into consideration and stop treating if the depression affects him so that he can't provide care appropriately. Dr. BADRE, the board's expert witness, who is a board certified psychiatrist, found Dr. BADII to, quote, have a nuanced and intelligent understanding of his mental illness, end of quote. That's in Exhibit 7A135 in the record. As a protective measure, Dr. BADII has also remained in voluntary psychiatric treatment under the care of Barbara Smith, MD, PhD, since March of 2018. She resides and practices in San Diego. So let's look at the forensic psychiatric opinions of Nicholas BADRE, MD, the board's expert. Dr. BADRE's mental status examination of Dr. BADII supports that Dr. BADII is safe to practice. And I quote from Dr. BADRE's report, quote, he is intelligent and eloquent. His insight and judgment were reasonable. I do not find his understanding of his diagnosis to be evidence of poor insight. To the contrary, I found his understanding of his mental illness to be quite insightful. And I quote another statement by Dr. BADRE. Quote, overall, I do not have significant evidence that Dr. BADII currently suffers from symptoms of severe mental illness. Now, severe mental illness is referred to as a psychotic illness, essentially. Now, Dr. BADRE answered 6 key questions posed by the medical board. And I'll go through each one of those 6 questions and the answers that Dr. BADRE provided. The first question he was asked is, does Dr. BADII have a mental illness or condition that impacts his ability to safely engage in the practice of medicine? His answer, and I quote, I do not find evidence that Dr. BADII has a mental illness that would impact his ability to safely engage in the practice of medicine. And you can see that in Exhibit 7A136. He states, further, mental illness is common and in itself is not an exclusion to the practice of medicine. And that again is the same reference of Exhibit 7A136. The second question that was posed to him was, is Dr. BADRE's presentation possibly due to a physical illness, such that a physical examination is necessary? Dr. BADRE's answer, I do not find evidence that Dr. BADII necessitates a physical examination. That's also on A136, Exhibit 7. Number 3, which is probably the most important question that was asked of Dr. BADRE. Is Dr. BADII able to practice medicine safely at this time without any restrictions or conditions? Dr. Badri's answer, Dr. BADII is able to practice medicine safely at this time without any restrictions or conditions. That also is on A136, Exhibit 7. The fourth question he was asked, which is similar to the previous question, is Dr. Badri unable to safely practice medicine at this time as a result of mental illness or condition? Dr. Badri answered, Dr. BADII is able to practice medicine safely at this time. Again, Exhibit 7, A136. The fifth question Dr. Badri was asked is, does the subject physician's continued practice of medicine pose a present danger or threat to the public health, welfare, or safety? Dr. Badri's answer, I do not find evidence that Dr. BADI's continued practice poses a present danger or threat to the public. That is on the same page, A136, Exhibit 7. And the last question, the sixth question he was asked, does the subject physician, Dr. BADII, have a mental illness or condition which requires monitoring, treatment, oversight, or other terms and conditions in order to practice medicine safely? Dr. Badri's answer, Dr. BADII's mental condition requires him to be engaged in psychiatric treatment at this time, which he does. Again, Exhibit 7 at A137. Punishment is not a goal of the medical board. The board's highest priority is to be the protection of the public. And secondarily, discipline should, and I quote, aid in the rehabilitation of the licensee. End of quote. That's in, again, section 2229, subdivisions paren A and paren B. The purpose of discipline is to make the respondent a better physician. And that can be found in the case of Wyndham v. Board of Medical Quality Assurance, 104 Cal App 3rd 461 at page 473. That is a California Court of Appeals case from 1980. The evidence supports the fact that Dr. BADII is aware of his diagnosis and has been compliant with his psychiatrist's treatment and recommendations. And that you can find in Exhibit 7, page A135. And the opinions of Dr. BADII's treating psychiatrists are highly relevant. This is Dr. Smith, who says, throughout the course of treatment since March of 2018, Dr. BADII's mental status has been stable. He is aware that he has an unspecified bipolar disorder and has been taking his mood stabilizing medication throughout his treatment. He is compliant with treatment recommendations. He has never presented impaired or in any way disabled. His mental status has been unremarkable. For the time we've spent together, there is no apparent reason for any concern regarding his ability to practice medicine. That's in the letter by Dr. Barbara Smith, dated January 7, 2022. It's in attachment 1 of the petition for reconsideration. You know, many physicians have mental disorders, same amount of mental disorders as the general public. Under circumstances presented here, probation would be a harsh punishment with significant collateral consequences to Dr. BADII, and that would severely impact his career. Absolutely unnecessary for public protection based on the medical board's own expert witness, Dr. Badri. Thank you.
All right, Mr. Chambers, please tell me when you are ready. You are muted.
We'll try that again. Thank you, Your Honor.
All right, you may begin.
This is a straightforward issue. The Superior Court has required the board to impose a term of discipline short of revocation in light of that court's decision. Respondent, at the commencement of his argument, listed off a number of states where he is licensed. He failed to note that his ability to practice in half of those states has been suspended. His failure to present a full and complete picture appears to be a running theme throughout this case. In April 2020, the state of Maryland imposed a minimum one-year suspension on respondent's license due to mental incompetence and failure to cooperate with that board's investigation with regard to prescribing issues. He is not allowed to practice in the state of Maryland until he is deemed safe. In 2022, respondent agreed to a consent order with the state of Connecticut, which waived his right to contest allegations that he has a mental health condition and that, if not properly managed, do and/or may affect his practice as a physician and surgeon. Disciplinary guidelines in California call for minimum 5 years probation for licensees impaired by mental illness or who have been found to have committed unprofessional conduct. Additionally, the guidelines call for and complainant requests the following: a written examination, psychiatric evaluation, psychotherapy, medical evaluation and treatment, practice monitoring, and a prohibition with regard to solo practice. Psychiatrist who was appointed by the medical board, Dr. BADII, testified about his October 2020 evaluation of respondent and characterized respondent's condition as, quote, severe, close quote, and testified unequivocally that continued psychiatric treatment and monitoring is necessary in order for respondent to safely practice medicine. We noted in the written argument provided to you that respondent's psychiatric condition has many times caused him to be unable to work, and that it is essential that he is under the treatment of a medical provider that can assist him in knowing when he can work and what are the best treatments. You'll find that in the transcript at page 21. The board's expert explained that it cannot be left up to respondent to determine whether he is unable to work, as he is not a psychiatrist and does not have the expertise to make these decisions on a consistent basis. You can find that in the court transcript at 25. Of importance to the expert's optimistic outlook that was presented by counsel this afternoon, Dr. BADII testified that he understood from his interview of respondent that respondent was willing to work with the board to ensure he received adequate treatment and oversight for his condition, and that the respondent was adamant about showing the board that he was in compliance with treatment recommendations. You can find that in the BADII report at A131 in the transcript, page 21. However, it would appear from what we have heard from respondent that he's only willing to work with the board if he agrees with the board's determinations. In fact, at hearing, he argued that there was no basis for imposing any monitoring terms. Respondent offered no explanation for his failure to cooperate with the Maryland board's investigation, and he did not represent that he would comply with terms imposed by the Medical Board of California. This is a man who spent a good deal of time testifying, as was noted by the ALJ in the decision, in a meandering, somewhat grandiose and implausible manner. For example, respondent testified that in spite of achieving the highest scores in many fields, he, quote, settled, close quote, on internal medicine as a specialty so that he could have family time. Transcript, page 46. He was able to diagnose conditions everyone else missed. That was at the transcript, page 48. He was recruited to surgical specialty training because on the first day of his surgical rotation, news of his quote, handiwork, close quote, got out. That's at page 53. And he won recognition as Doctor of the Year while in practice at a hospital. That's at transcript, page 55. Respondent attributed his problems in Maryland to a dispute with a former business partner and respondent's former wife. And according to respondent, his ex-wife stole his medical records, altered them to add a diagnosis, and sent them to a former business partner associate who in turn sold the falsified records to Advantis Corporation for $250,000. Advantis, he explained, was willing to pay for the records because in 2015, respondent filed an antitrust suit against Advantis and is a threat. That's the transcript pages 65 through 67. Amazingly, respondent testified that he reported the incident to the FBI in August 2020. That FBI's agents, quote, took my testimony out in my yard, close quote, and asked him not to notify local law enforcement because the FBI wanted to handle the matter. That's the transcript pages 66 through 67. Unsurprisingly, no 302 report, which is a summary of an FBI interview, was ever produced at hearing to support these claims.
Excuse me, counsel. Excuse me, you got glitchy there. I lost you at I'm surprised. Thank you.
Unsurprisingly, no interview documentation was ever supported at hearing. Respondent's explanation of the history of his depression was inconsistent with the history he provided to Dr. BADII. For example, respondent described in detail a depressive episode during medical school in which he was admitted to the hospital for 24 hours for psychiatric treatment because the school did not want any publicity, following an unfortunate event with another medical student. Transcript pages 50 through 52. The account provided to Dr. BADII describes a voluntary 3-day hospitalization for depression resulting in a diagnosis of bipolar not otherwise specified. At the Dr. BADII's report A-126. The ALJ did not make the wrong call when she proposed revoking respondent's physician's and surgeon's certificate. Neither did this board when it issues a decision revoking the certificate. But we're here today to put the best spin on a bad ruling by a Superior Court judge. But for the terms and conditions outlined at the beginning, along with the 5 years probation, there is no way the board can fulfill its mandate under Business and Professions Code section 2001.1 and 2229. There was discussion that there has been no harm to patients at this point in time. But as we all know, the board does not have to wait until there is patient harm. We know that from case law, Shanuda versus Veterinary Medical Board, the 2018 case. This isn't even a close case. The evidence was presented to the medical board, it was presented to the ALJ, it was reviewed, it was decided. Superior Court judge made a decision that we disagree with, but we have to comply with. This individual, this licensee, cannot practice without proper monitoring for a period of 5 years. Thank you.
All right, the parties will now have 5 minutes for closing argument. And Mr. Firestone, please tell me when you are ready.
I'm ready, Your Honor.
You may begin.
Mr. Chambers began his presentation with some facts about Dr. BADII's license in Maryland and Connecticut. So I would like to give a little bit of background about those two issues, since he is raising questions but not answering them. Dr. BADII, was in practice in Maryland, at which time he and his partner had some difficulties in their in their practice and their business aspects. And that led to an investigation prompted by his ex-partner. At the hearing in Maryland, the administrative law judge did not recommend revocation of his license, actually was based on the facts, had recommended dismissal of the accusation in Maryland. But the medical board in Maryland decided that Dr. BADII, had not fully cooperated in the investigation by the board by not appearing for a couple of the interviews, and therefore revoked his license. And of course, when a doctor loses his license in one state or is disciplined, it's a domino effect. Almost every state now picks up that information and takes its own action. And therefore, Connecticut filed an accusation against Dr. BADII based on what occurred in Maryland. By the way, the Maryland case is in the process of being still litigated there. In Connecticut, Dr. BADII, rather than fighting that, decided to enter into a stipulation for a 1-year probation, which will be completed next month. Now, Mr. Chambers says that Dr. BADII was diagnosed with severe mental illness. However, if you look at page A136, Dr. Nicholas Badre, the only expert witness to testify in this matter, stated, and I quote, "Overall, I do not have significant evidence that Dr. BADII currently suffers from symptoms of severe mental illness," end of quote. And that's in Exhibit 7, A136. Mr. Chambers ends up his argument by criticizing the Superior Court judge. And yet, the Superior Court judge reviewed all the matters, heard arguments on both sides, looked at the evidence, and said that this was an abuse of discretion. I mean, after all, the administrative law judge only had one expert witness about Dr. BADII's mental disorder that he admitted. There was no other expert other than Dr. Nicholas Badre, who is the medical board's expert witness. And yet the ALJ engrafted her own opinions because Dr. BADII tended to go off on a tangent and try to explain things that could not be explained in the hearing. And so the administrative law judge thought somehow this guy must be crazy.
40 seconds, Dr.
Dr. BADII is here, and he's happy to answer any questions that will reassure you that he does not have a severe mental disorder and is essentially the same person that was evaluated by Dr. Nicholas Badre. Thank you.
Mr. Chambers, please let me know when you are ready for your 5-minute closing.
I'm ready. Thank you, Your Honor.
All right, you may begin.
We can all cherry pick information that's beneficial to our argument. So look at the situation in its totality. Look at the entire transcript of Dr. Badre's testimony. Look at the entire transcript of or the entire report in Exhibit 7. It's not as pristine and clear as you would hear in the argument from opposing counsel. This is not an individual who should be practicing without supervision. Dr. Badre testified to that. The report surely shows that there are issues with the individual that need to be addressed. The Superior Court judge made a ruling because there was a single expert who made some nice positive comments about the licensee. But the Superior Court judge ignored the observations of the ALJ, who was present and witnessed the testimony of the licensee. The Superior Court judge also ignored statements made by Dr. Badre, the board's expert. We can all cherry pick, but the fact is the public cannot afford to have this panel cherry pick. This panel has to look at the situation with the totality of the circumstances, all the information that's been presented to it, if it is to keep this public safe. You've heard the business profession codes that are pertinent here, 2001.1 and 2229. Dr. Badre, Dr. Badie can be rehabilitated, but he is not safe to practice.
Well, Mr. Chambers, we lost you there for a moment. All right, I'm going to stop the time.
His video locked up as well too. I don't know if we lost him altogether or not.
Let's just wait a moment and see if he joins us back.
His line is still open, so if he were still there, we'd hear him audibly. So I think we've lost him. We might need to give him a few minutes to connect again.
All right, let's go off the record while we wait for Mr. Chambers to join us back. Off the record.
Looks like we got him back now.
All right, Mr. Chambers, can you hear me? And you're muted, Mr. Chambers. I don't know if you can hear me yet. Okay, unmute yourself. Can you unmute yourself, Mr. Chambers? No.
Let me try making him an attendee and bringing him back as a panelist.
I'm unmuted.
All right, Mr. Chambers, I can hear you, but I can't see you. There we go. All right, we went off the record. I'm going to ask Ms. Temple to please tell you before we go back on the record what she last heard from you, and then I paused the time at 2:52. Ms. Temple, can you tell Mr. Chambers where you last sentence?
Yes, thank you, Your Honor. Unfortunately, because I couldn't get in, I had to change my setup. So I don't have my notes that I can access at this time.
All right, so my last recollection is that you were speaking about the board not being able to take a chance with the public. So if you could, we can go back on the record if you could just pick up from that portion. All right, back on the record. All right, we were back on the record. We lost Mr. Chambers, and our court reporter does not have her notes. So, Mr. Chambers, if you could please just pick up back up on your closing argument. You have 2 minutes and 52 seconds remaining. You may begin.
The board is well aware of Business Professions Code Section 2229 and 101.1. This physician can be rehabilitated, but not without proper supervision and monitoring. Board's requesting 5 years probation and the terms and conditions that have already been laid out. Board has to look at this in the totality of the circumstances, not by cherry picking individual facts and beliefs and claims. Thank you.
All right, Mr. Firestone, does Dr. BADII wish to address the board with regards to appropriate penalty?
Honorable members of the medical board.
No, Mr. Firestone, you don't
No.
have any additional time. I'm asking if Dr. BADII wishes to address the board.
Oh, excuse me.
Does Dr. BADII wish to address the board with regards to the appropriate penalty?
I think he's just going to respond to any questions that are asked, Your Honor.
All right. If there is questions asked of Dr. BADII, then I will swear him in. If there's not, then I will not. I'm going to now open up any questions. If our panel members have any questions, starting with our chair, please.
No questions on my end.
All right. Any questions from our vice chair?
Yes, Dr. Hawkins, you can hear me?
Yes.
We're all
Sure,
aware.
I can.
You can. We're all aware that.
Do I have to be sworn in first?
Oh.
No, so Dr. BADII, unless a panel member has a specific question for you at this point, they can direct their questions to counsel. Unless they tell me they have a specific question for you, I don't need to swear you in. Dr. Hawkins, is this question to counsel?
It's to Dr. BADII.
Oh, it is. All right. Then Dr. BADII, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name.
Roozbeh BADII. First name is R-O-O-Z, B as in boy, E as in Edward, H as in house. Last name is BADII, B-A-D, 2 I's.
All right, Dr. Hawkins, you may ask any questions you have. And just reminding you, just limit your questions to information, evidence that's already in the record.
Okay, and I'm sure you'll stop me if I get out of line with that. So I have three questions I'm sure our members are interested in. One is, what happened in Maryland that prevented you from cooperating with that medical board? It's unusual to suspend license, but if the board cannot get information, and there's a question of competency, they often have no recourse but to suspend the license. That's the first question. What happened that prevented you from cooperating with the medical board in Maryland? The second one is that the current psychiatrist, Dr. Smith.
So Dr. Hawkins, let's go ahead and just have him
Okay.
answer the first question before you go on to the next. And just again, remember, this is limited to evidence that's already in the record.
Can I
So
ask a question? Exactly.
There was testimony with regards to why, Dr. BADII, you did not cooperate with the Maryland board.
And I'd like to hear it from him again.
My medical records were falsified and given to the board. Now, this is clearly apparent. That's why Captain Daryl Williams came to my house in August 2020, former FBI captain. That's why I called him to my house, and he gave a recorded 30-minute conversation to Melissa, his active partner at the FBI field office in San Diego. I am being treated in California by Barbara Smith, MD, PhD. I'm not going to go to Maryland once a week. That's what they're requesting. To be treated by a second psychiatrist who has his assessment based on falsified medical information. They don't know what they're doing because I have been practicing, I've been treated, and when you do not have falsified medical records given to Dr. Badre, you come up with the correct assessment. That is what happened over there. They know those medical records are falsified. They offered my license back to me, but I refused.
Okay, thank you for that. My comment is that, not related to my question, is that your current psychiatrist update is helpful, although it's somewhat dated since it's a year old. Can you clarify for us if you're willing to accept monitoring by your own psychiatrist and monitoring by the board to confirm that the proper care is being given to the citizens of California?
It all depends what kind of monitoring. I am willing to be monitored by my own psychiatrist and somewhat unhindering monitoring that by the board. But you have to understand, no one is giving me a job anymore because of all this nightmare that has been in my life. So I don't know how I'm going to get a job. Even my friends won't hire me. So I am willing to be monitored definitely by my psychiatrist, Barbara Smith. But I don't know how the board is going to monitor me, and to what extent for me to be able to accept monitoring. But I do not want probation. I'm almost finished with 2 years of probation in Connecticut. I have 1 more month left, and it's completed. Another 5 years in California? That seems unreasonable. And what makes the probation in California different from probation in Connecticut? Homo sapiens are everywhere the same. Treatment is the same. What makes it much difference? I don't understand it. It might just be the laws that I'm not aware
So
of.
let me just ask.
But probation is.
So let me just ask a question then. I'm talking about medical monitoring. So in Colorado, did you have a physician review your charts and report to the Connecticut board saying, yes, he's practicing at a level that's good, blah, 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 blah. This is what I'm asking. That's what monitoring means.
Dr. Hawkins, just to correct the record, it was Connecticut, not Colorado.
That's what I meant, Connecticut. I'm sorry. That's my last question. Please answer that one.
Okay, just a reminder, please. Please don't talk over each other. Our court reporter cannot take down two people talking at the same time. So just please give a brief pause so that you're not talking over each other. Dr. BADII, do you understand the question?
Yes, I do, Your Honor.
All right, please answer that question.
Every quarter, Dr. Andrew Sackler has evaluated my performance in Connecticut and reported it to the practice monitor in Connecticut without any problems in the last 2 years. I have one more quarter left, which ends February 28th, and that's it. I am done. So another 5 years here, I don't understand.
That answers my question. Thank you. No more.
Dr. Bullet, do you have any questions for Dr. BADII or the council?
Yes, I do. Thank you. So it'll be specific. Dr. BADII is already sworn in, so I may proceed, Your Honor.
You may.
So Dr. BADII, for many years, you've lived with a mental health condition. You self-treated because of cost for a little while, meaning that you got some medications outside to decrease cost. And currently you're under the care of a psychiatrist. Can you, I think you just explained it, but one more time for me. Can you say why you don't think imposing additional monitoring to protect the people of the state of California, that oversight by this board, I think I heard you say it's not fair. Can you give me why you think that this board may be in this position? And I'd like to hear from you, because sometimes people have ideas and I'd like to hear them as to why you're in this situation in California.
Okay. So the reason is that I'm already being monitored in Connecticut for 22 months now. I have 2 months left. If something would have come up, especially the false medical records that were not only tried to get an advantage in family court, does another 5 years, is that something that's reasonable? Or do we need another 50 years or another 5 months? I understand the board guidelines call for 5 years, but not only, it's just extra long after if you had put me on probation 2 years ago, within 1 year I could have applied to get off the probation. I have never been impaired ever. This is an allegation that I might become impaired. So I don't even know what the diagnosis really is, and nobody knows. I know that I get moody when there's extensive cloudy weather. I know that. Okay. How is someone going to call me and tell me oh, it's cloudy, don't go to work? It just doesn't make sense to me that I should have another 5 years when I have almost completed the probationary terms in Connecticut with 2 months left. I just don't see the redundancy in it. We can put me on probation for 50 years until I die or stop practicing medicine. If you want to monitor me, then you have to monitor me forever. Or just 2 years of Connecticut should be enough.
Thank you, Dr.
Can you hear me?
Yes.
Can everybody hear me? Okay.
Thank you, Dr. BADII. Thank you.
Right. Mr. Watkins, any questions for counsel or Dr. BADII?
Oh, no, thank you.
All right. Any additional questions from our panel members? All right, then, Mr. Firestone, is the matter submitted for the board's consideration?
Yes, Your Honor.
Mr. Chambers, matter submitted for the board's consideration?
Submitted.
All right, matter is submitted and the record is closed. We are off the record. All right, thank you. And I will turn it back to our chair, Ms. Lubiano, to call our next matter.
And
Thank
Ms.
you, Judge
Lubiano, if I could
Martin.
just have just a couple minutes to move the next group into the proper roles.
Okay, let me know when you're ready, Sean.
Thank you very much. Okay, I have Mr. Yates. Okay, there's Mr. Okay, I believe I have all the participants now in a panelist role. I haven't been able to check them in though since the meeting began, so we'll have to do that when the judge calls them in.
I apologize. This is Nick Jerkowitz. Could I get a few minutes? I just got a nosebleed and I don't want to be on video trying to deal with a nosebleed. Would that be okay if we get 5 minutes?
I will defer to our chair.
Yes,
Sounds
that's
important.
Thank you so much.
Right. And then I'll go ahead and then we can go ahead and check everybody in before we go on the record. That's fine. We can do that when everybody comes back.
Thank you very much. Appreciate that.
Thank you. Glad you're good to go.
Yes. The winter weather dries out my nose, sadly.
Moving to agenda item number 3, we are on oral argument on non-adopted proposed decision for Dr. Gruber. Judge Larson?
Yes, thank you. All right, I just want to confirm we have Mr. Yates is present, Mr. Jerkowitz, and Dr. Gruber is present as well, correct?
Yes, Dr. Gruber is here.
All right, in just a moment, we're going to go on the record. I will announce the matter. I'll have the parties announce themselves, and then I will explain how the hearing is going to proceed this morning. As soon as Ms. Temple tells me she is ready, we will go on the record.
I'm ready, Your Honor. Thank you.
All right, on the record. Good morning. We are on the record before the Medical Board of California, Panel A. This is in the matter of the First Amendment accusation against Michael David Gruber, MD. Medical Board case number 800-2018-044577. OAH case number 2022-120485. Today is January 4th, 2023. It is approximately 11:08 a.m. This is the date, time, and place for oral argument and the notice of oral argument. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this hearing. Prior to going on the record, the board members identified themselves and a quorum was established. May I please take the appearance of the Deputy Attorney General?
Ryan Yates for the Attorney General's office.
And counsel for respondent?
Yes, good morning. Nicholas Jerkowitz on behalf of Dr. Gruber.
And Dr. Gruber is also present, correct, Mr.
That is
Jerkowitz?
correct.
All right. The board has invited particular discussion whether the level of discipline ordered in this matter is sufficient to protect the public. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. Respondent will have 5 minutes for closing argument, and the Deputy Attorney General will have 5 minutes for closing argument. These time limits will be strictly enforced. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence in this matter. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Myself and any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of oral argument by counsel, I will offer Dr. Gruber an opportunity to address the panel regarding the penalty if he so chooses. If he does elect to address the panel, I will first place him under oath. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive a decision sometime in the future. Please remember that all arguments must be based on the existing record and no new evidence will be heard. Please also remember that the board has already had the benefit of reading your briefs. All right, any questions before we get started?
One question. Would it be, Dr. Gruber had intended to give a short statement first. Is that okay, or would the panel prefer that we go first as attorneys and then his statement come at the end?
I would prefer that he go at the end. I can swear him in at that time, and so you can focus on the opening statements and your 15 minutes, and then after oral argument, I will swear him in.
Very good, thank you.
All right, hold on just a moment. I need to get started, and then I will also do my best to give you a 1-minute warning as well. All right, Mr. Jerkowitz, please tell me when you are ready.
I am ready, Your Honor.
All right, you may begin.
Thank you very much, and good morning to the panel, and thank you for allowing us to appear and to provide you this information. As the panel knows full well, the purpose of the medical board, and particularly medical board discipline, it's about protecting the public. It's not about punishment. And I'd like to kind of just walk through some of the reasons why I think the ALJ in this decision did get it right. Not just from a factual standpoint, but from a disciplinary consideration standpoint as well. So the first thing I want to make sure that it's completely clear and that needs to be understood is that Dr. Gruber is not, nor has he ever been, a pain management doctor. This was not a practice in which he was providing pain management sort of specifically to these patients. He's a family medicine doctor. He was practicing medicine at a rural, low-income population clinic. He inherited every single one of these patients. That's a really important point. Dr. Gruber did not start any of these 5 patients at issue on any opioids. Each of them was inherited from a previous doctor who had, for a long-standing treatment, establish these patients at their level of opioid treatment and their prescriptions. Dr. Gruber was not just treating these patients for pain either. So I want to make sure that that's clear. Dr. Gruber was treating these patients as a family medicine doctor for the totality of their issues. Many of these patients were all of these patients were very sick. Many of them had comorbidities like diabetes, heart conditions, various musculoskeletal, ailments. He was treating all of this. It was not just a doctor who was looking at these patients for pain. Dr. Gruber was focusing on the totality of the treatment of these patients. And I think it's really important to sort of read between the lines on this. Not one issue was brought by the medical board about any of the care and treatment Dr. Gruber did for any of that other stuff. And again, as I said, these were very sick patients. Many of them were on dozens of medications, and all of that being reviewed by the board was found to be within the standard of care, or certainly no accusation was charged with respect to that. Another, I think, very important point to bring up is Dr. Gruber is in Colorado now. He has been in Colorado for a number of years now. Before this accusation was filed, he had already moved to Colorado. He is, as the evidence established, working at a VA in Colorado. So in terms of protecting the public in California, there is a very minimal potential for harm to any patient in California. I would say 0, but we should never talk in absolutes. He simply is not in California. He has no intention of coming back to California. And sort of segueing into that in terms of this is about protecting the public and not about punishment. I think it's obvious, hopefully it is obvious to this medical board that, probationary terms are significantly harder for a physician to deal with than not having probationary terms in general. It becomes significantly more complicated when you're talking about an out-of-state physician now. So there will really be, to put Dr. Gruber on probation, we have a public letter of reprimand proposed decision from the ALJ. to put Dr. Gruber on probation while he's in Colorado now really benefits the people of California minimally, if at all, but does significantly hurt Dr. Gruber's practice in Colorado, where he's had no issues, where he is, as I said, working at a VA and providing really good care and treatment, family medicine treatment to veterans in Colorado. Which also brings up another important point about this decision, which is the patients at issue were treated by Dr. Gruber approximately 4 years before this case went to hearing. And in that interim period, as I said, he not only moved to Colorado, but he continued to treat patients with no issues whatsoever in terms of opioid prescribing or in terms of any of the medical record keeping or any of the issues that are at play in the accusation or at the hearing. I also want to point out that Dr. Gruber won on most of the issues that were before the accusation. Particularly the ALJ found factually, and I don't think there's any basis for this panel, nor do I think the panel is even considering it, to reconsider any of the factual findings of the ALJ, which were well-reasoned and properly determined. But the ALJ did find that in terms of Dr. Gruber's prescribing, there were no issues. One of the main issues in this case was whether or not Dr. Gruber had failed to identify that the patients were suffering from opioid use disorder. That was a big accusation, and that was a centerpiece of the board's expert, Dr. Franklin. The ALJ agreed with our experts that these patients did not meet the clinical definition of opioid use disorder. In addition to that, one of the other major issues in this case was whether or not Dr. Gruber's prescribing of opioids was improper because of the level of morphine equivalents that he was prescribing to these patients. And the board's expert had essentially opined that, look, there is an actual number threshold and you have to meet that threshold. And our experts disagreed, and the ALJ agreed with our experts that there is no threshold that you have to be below. That Dr. Gruber had inherited these patients, all of whom were on very high doses of opioids, dependent but controlled. The patients were on high doses, but they were in a controlled state, and he did the best he could to wean them down. And he did wean down most of the patients. The board's expert somewhat arbitrarily, and the ALJ did not agree, that the weaning had to be done at a certain level, at a certain speed. And that simply is inconsistent with the CDC guidelines, and it was inconsistent with the standard of care as found by the ALJ. Dr. Gruber tried the best he could to wean them down, and he did, as I said, wean them down. And it's important that when we're thinking about this, that, when you're weaning down a patient from high doses of opioids, you can't go more than is reasonable and practical with the patient, because for two reasons. One, the patient could have withdrawal and show dangerous effects as a result of the withdrawal if it's too fast. But two, as we know, the patients will seek the medications on the street if they start going through that withdrawal process. So Dr. Gruber had to be very careful in how he treated these patients, and he did, as the record shows, wean them down as appropriately within the standard of care. There was another major point within the other major point I wanted to state was what really Dr. Gruber was found to be the accusation was supported was really medical record keeping. There's two issues. There was the fact that the medical records don't support the ordering of urine drug screens. And there was just in general, the medical records were lacking from a general standpoint. So with respect to the urine drug screens, Dr. Gruber did testify that he did order urine drug screens, and those records of the urine drug screens were not part of the medical records that were provided to the medical board. But again, this was a large clinic. It was a hospital system, so I believe it was an Adventist system. So the fact that those records were not part of the record doesn't mean that they didn't exist. But more importantly, there was no abuse with respect to any of these patients. And then in addition, there was just general record keeping. which supports another reason why the decision is sufficient. So the discipline that was recommended by the ALJ is public letter of reprimand with record keeping. With coursework, 1 in record keeping and 2 in prescribing practices. So again, when you're looking at an accusation here and the findings that are against Dr. Gruber really center around record keeping, they either are specifically record keeping or there's this related issue of the records not reflecting that urine drug screens were ordered. A prescribing course and a record keeping course does properly address those deficiencies. And as I said before, really there's going to be no benefit to putting Dr. Gruber on probation. I want to just highlight a couple of mitigating factors that I think the ALJ properly considered, because what the ALJ—
I'm sorry, counsel. You were glitchy there.
Oh.
You said, can you just start that sentence over? I want to.
Absolutely. I want to highlight some mitigating factors that the ALJ considered. And, obviously in this case, the ALJ deviated from the recommended guidelines. And she provided a pretty long, about a page and a half or so, explanation as to why she felt it appropriate to deviate to the lower end of the guidelines. And she looked at a number of mitigating factors. And I think that these are really important to highlight. So first of all, the patient population here is a rural, underserved population. As far as the medical board should be concerned in terms of the policy that's set by this panel, we don't. I think that it is important that doctors be incentivized to treat this population, this rural, underserved population. And Dr. Gruber came into this environment already with these patients having established the care they got. There is a potential de-incentivization of physicians to go into these patient populations knowing that they're inheriting some patients who have perhaps sketchy, I shouldn't say sketchy, but perhaps not the best treatment prior to their arrival there. There was no harm to any patients at any time through the care and treatment that Dr. Gruber provided to these 5 patients. He's been practicing medicine for 35 plus years with no history of any disciplinary issues whatsoever. Again, the patients were treated 4 years ago before the case went to hearing. So a lot of time had passed from the events to when the testimony was provided. He's a very well-respected, good physician. We had some very good, a lot of letters of support from colleagues, and then we had testimony from 2 physicians. One was Dr. Thorpe, who testified based on his experience with Dr. Gruber that he's an excellent physician. And we had Dr. Gruber's current supervisor at the VA, Laura Probst, who testified that Dr. Gruber's care and treatment at the VA has been, fantastic, and there have been no issues at all. Now, finally, I want to address just one point raised by the Deputy Attorney General in the papers, and hopefully you'll hear from Dr. Gruber in a few minutes, this concept that Dr. Gruber didn't accept responsibility. I disagree with that, and I think the record overwhelmingly disagrees with that as well. Dr. Gruber did defend his care and treatment of the patients, but that doesn't mean he doesn't accept responsibility or didn't take the process seriously. Dr. Gruber acknowledged at the hearing that his records could have been better. He acknowledged that his record keeping wasn't perfect. So I think Dr. Gruber did understand the severity of this. He does take opioid prescribing very seriously. This is not a physician who is just handing out medications to, totally healthy patients. This is, again, a doctor who understood very well the opioid problem and the risks that come with opioid prescriptions, but again, had to manage and did a really good job of managing his patients in that setting. So thank you.
All right, thank you. Mr. Yates, please tell me when you are ready.
Your Honor, thank you.
And before you get started, you sound a bit far away, so you're going to need to keep your voice up. And I see our court reporter shaking her head. So Please make sure that you keep your voice up so we all can hear you, all right?
Okay, should I try and move my desk up a bit?
Well, as long as you talk that loudly, you'll be fine. But if you think that you're going to have a hard time maintaining that, you might want to move a little closer.
Okay, I'll project. Sorry, I have winter throat, so I'll do my best.
All right, you may begin.
Good morning, everyone, and thank you for allowing me to speak. Quite simply, the decision and the penalty are inconsistent with the factual findings. At this point, everyone has read both briefs, so I won't rehash. But the most important parts of the decision, as I see it, are these. One, the decision, page 50, paragraph 126, quote, "The evidence established respondent committed simple departures from the standard of care by failing to include ER toxicology screens in the medical records and not ordering toxicology screenings of his own. The evidence further established respondent failed to maintain accurate and complete medical records." End quote. This was ongoing and regarding 5 different patients. 2, paragraph 127, "The proven misconduct is serious." ALJ King then goes on to explain why this misconduct is so serious. 3, page 51, paragraph 129. The ALJ then states that the imposition of a public reprimand does not fall within the disciplinary guidelines of recommended discipline. Those guidelines provide that 5 years minimum probation with several terms and conditions is the minimum guideline, the maximum being revocation for that sort of misconduct. Quite simply, we are dealing with an extreme departure from the board's guidelines. Now, regarding gross negligence, we talked a little bit about it, and several grounds for gross negligence were not sustained. Obviously, as the prosecutor, I disagree with those findings. However, if the board were to sustain those gross negligent allegations, we would land somewhere around the same MBC disciplinary guidelines as repeated negligent acts and record keeping for multiple patients, which was sustained factually. And that's that 5-year minimum period or above. So I'm not going to go too much into gross negligence because I do believe even if we were to rehash that, we'd probably land in the same area. But regarding those sustained allegations, first, the penalty does not fall within the guidelines or anywhere near. So how can an ALJ mitigate a penalty? The MVC guidelines provide for penalty mitigation, which state that the board expects that absent mitigating or other appropriate circumstances, such as early acceptance of responsibility, demonstrated willingness to undertake board-ordered rehabilitation, the age of the case, and evidentiary problems, administrative law judges will follow the guidelines. And so I think the most important here, which we talked a little about, is there really is no acceptance of responsibility, or especially an early acceptance of responsibility, or remorse, or really any sort of willingness to undertake board-ordered rehabilitation. You can see that in the transcripts in portions of my brief, which highlighted some of those statements, but obviously there's a disagreement. I urge all of you to reread the transcripts and figure out for yourself whether you agree with our position that there's no acceptance of responsibility or remorse or a willingness to undertake any sort of board rehabilitation. In fact, I submit that respondents' attitude towards these proceedings is more of an aggravator. So when you see a public reprimand with coursework, I ask you, what good is coursework when the respondent doesn't believe he did anything wrong? What's the point of sitting through a class if it's going to go in one ear and out the other? So I urge you to consider monitoring so that we can actually provide that public protection rather than a course where somebody just might kind of sit through and not really take anything seriously. The age of this case is another interesting point that was cited to. This accusation alleges misconduct from 2016 ongoing through 2018. And that's something that just isn't unusual for these overprescribing cases. It takes a while to investigate it takes a while to get through expert review. The accusation was filed 5/30/21, and the hearing was held 6/22. There was some time between the accusation and hearing. I don't want to get off the record, but as you can see through the record, there have been some continuances that were agreed upon by both parties. So I think if we're going to use the age of the case as the primary mitigation to cut a penalty from the lowest MVC guideline to a public reprimand, I think it's just bad public policy. That could encourage unscrupulous attorneys to set as late as possible or engage in bad faith continuances for settlement purposes. Then when a hearing comes, the old age all of a sudden becomes the primary mitigation to a lesser penalty that's far beyond the guidelines. So I'm not saying that happened here, but the use of the age of a case as a mitigator to substantially reduce a penalty, it could possibly reward bad behavior.
Excuse me, counsel, you cut out.
Okay.
You cut out. I lost you, but the use of, thank you.
Sorry, so I think the use of primarily the age of the case to reduce a penalty beyond the guidelines, I think that could potentially reward bad behavior in future cases. I think when we're looking at the age of a case, we need to have considerations like 7-year statutes. We need to have considerations such as changed law or changed standard of care, not just the mere age of a case, because that doesn't wipe misconduct off the board in and of itself. But then other than that, the other mitigators that I saw that was referred to, it's pretty garden variety. We're talking about no prior discipline during a long career, letters of recommendation from colleagues, which are hard not to get. And, I've never seen that sort of mitigation information in of itself modify a penalty substantially from the guidelines. So the guidelines also state that any proposed decision or settlement that departs from the disciplinary guidelines shall identify departures and the facts supporting the departure. So here ALJ King does identify the departure, but there's really kind of a vague usage and a broad usage of public protection, but it doesn't really get into that, quite simply stating that these courses are enough. So with that, I conclude. Thank you.
All right, Mr. Jerkowitz, please let me know when you are ready to begin your 5-minute closing.
I am ready. Thank you.
All right, you may start.
Thank you. Just to address some of the points raised by counsel. Mr. Yates read from paragraph 126 on page 50. However, he omitted the last sentence. He read what portion he read, but he omitted the next sentence, which I think is really important to state the context of what he read. The last sentence of that paragraph says, the more substantive allegations regarding gross negligence, overprescribing of pain medications, and incompetence were not proven. Mr. Yates argued that, gross negligence should be found here, or suggesting that. I wanted to add one point. As I said before, there's no basis to reconsider the findings of the ALJ, but an important point here is the entire case against Dr. Gruber was based upon a non-pain expert, family medicine doctor, an internal medicine doctor that was the expert for the board. Our experts were two very highly respected, experienced. One was an addiction specialist physician, and one is an anesthesiologist who specializes in pain management. And Dr. Berger actually used to teach the fellows at USC. So again, the idea that gross negligence should be established, I think it's important to remember, as the judge pointed out, this really was a battle of the experts. And when it came to those issues of overprescribing, incompetence, simply put, our experts were more credible. Mr. Yates discussed about monitoring, that in order to protect the public, Dr. Gruber needs to be monitored, and that coursework with a PLR isn't sufficient for that. I just want to point out, the only difference between probation and a PLR in this case, because Dr. Gruber is to take this coursework, the only difference between the two would be monitoring. I mean, it's just as much of a stain on your record to have the PLR up there on the website as it is to have probation. The only difference as far as the medical board and the people of California would be concerned would be the actual monitoring on a monthly or quarterly basis of Dr. Gruber. And again, he's in Colorado, he's not in California. There's really no benefit to the public to have that additional monitoring. The coursework is going to sufficiently educate Dr. Gruber to the level he needs to be to avoid this. And in terms of the age of the case, as Mr. Yates spent some time discussing, I think perhaps my point on that may not have been clear or was misunderstood. I'm not saying simply that because, and the ALJ wasn't saying the same thing, that because the case occurred 4 years before the hearing, or the cases were 4 years before the hearing, that in and of itself is mitigation. It's really what happened in those 4 years. We have a doctor who has transferred his practice. He's in another place and he's doing great. And none of these overprescribing issues that were alleged against him, or these record-keeping issues against him, those have been rectified at this point. We don't have that problem anymore. And finally, there was, Mr. Yates discussed about, certain mitigating factors like changes in the law. And one thing that did come up at this hearing is that since the time Dr. Franklin gave his opinion and reviewed these cases, there was somewhat of a change in the law. We had the 2022 CDC guidelines. So the new guidelines that came out in 2022, I don't know at this point when they're effective, but the CDC did issue new guidelines on overprescribing issues and prescribing opioids. On prescribing opioids, I shouldn't say overprescribing, on prescribing opioids. And those new guidelines refuted a lot of the position that Dr. Franklin had and supported a lot of the care and treatment that Dr. Gruber did and supported the standard of care as opined by our experts. So thank you.
Mr. Yates, please tell me when you are ready for your 5-minute closing argument.
Thank you, Your Honor. I'm ready.
All right, you may begin.
So regarding the issue of gross negligence, and once again, I do want to focus on penalty because I believe if we focus on penalty, we would arrive at the same place. But as the board, you can make factual findings. Those findings must be backed up in writing. Legally, the board is supposed to give great weight to the ALJ's factual findings. So if the board is going to make different findings, justification must be provided. So in short, regarding that, as the board, those are really the only requirements. But to address those, the argument, the back and forth, there was some mention of comorbidities for these patients, that they were very sick, that they were very ill, that they were being managed these really high prescription regimens. Well, yes, there are very sick patients, and that goes to the importance of making sure toxicology screens are engaged in and making sure those records are appropriate, because these are the sorts of patients that you need to really, really manage, and you need to write down that management. Regarding Colorado, sure, he is in Colorado, but there's no restrictions on his license currently. So if he is to come back, if you did choose to practice in California and come back and practice there, there would be no issues, there would be no restrictions. He would be free to practice how he wishes in California without any sort of monitoring. Now, to finish up, the guidelines, they exist to promote unity and fairness in providing a penalty. That's why they're there. We want to make sure that doctors that engage in the same misconduct are treated the same. And they were written down, and there are rare exceptions and examples of when an ALJ should depart from those guidelines. A respondent engaged in ongoing repeated negligent acts and improper record keeping with 5 patients. That's largely agreed. As such, the penalty should be a minimum of 5 years and a maximum of revocation. The current penalty simply is not supported by the factual findings or the law. Now, as you can see from the record, we are not advocating to revoke respondent's license, but we believe that he can be rehabilitated. However, a probationary period is necessary for that public protection, and it's necessary for that rehabilitation. Coursework in and of itself simply does not cut it. There is simply not mitigation evidence that would justify going anywhere outside of that 5-year probationary term. So for the foregoing reasons, respondents, physicians, and surgeon certificate should have a revocation stayed and placed on probation for a term of no less, and we recommend 7 years, with education coursework, medical record keeping course, ethics course, clinical competence assessment program or PACE, solo practice prohibition, and the standard terms and conditions. Thank you.
Right, and I understand that Dr. Gruber would like to address the panel members with regards to the appropriate penalty. Is that correct, Mr. Jerkowitz?
Yes, Your Honor.
All right, so Dr. Gruber, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You're muted.
I do.
All right. You may lower your hand. Please state and spell your name for the record.
Michael Gruber, I-C-H-A-E-L, last name G-R-U-B-E.
All right, Dr. Gruber, I can barely hear you, so I don't know if you can get closer to your microphone.
How's this?
It's still a bit faint, so you're going to need to keep your voice up.
Okay.
And I want to remind you again that you may address the panel members with regards to the appropriate penalty. You may not present any new evidence that's not in the record. Do you understand?
Yes, I do.
Okay, you may begin.
Good morning, Your Honor and esteemed board members. I'm Dr. Michael Gruber. I find myself in this place I never thought I would be. It's humbling and it's humiliating to be here. When these kinds of emotions comes up, there's always a lot of lessons to be learned, and I hope I'm learning mine. The board has a responsibility to oversee the prescribing of opioid medications. They're complicated and dangerous. They create all sorts of societal problems. They are a concern for the particular patient as well as the community. This is important work, and I understand why and how I came before the board. I also believe we have shown I am not guilty of the bulk of the charges brought against me. There's been a lot written and a lot said about this situation. There are dueling experts saying opposite things. I take some solace in the fact at least 2 qualified and knowledgeable experts in the field find my medical care mainstream, and in Dr. Berger's case, commendable. I strive to provide commendable care. I had a successful academic career. I graduated 5th in my medical school class of over 200. I could have gone into any field of medicine. I chose family medicine. I believed family medicine would afford me the best opportunity to interact with and help those in need. I went to a rural residency program and spent the bulk of my career in rural and underserved areas. I learned to speak Spanish to better serve my clientele. I've worked for community health centers, Indian Health Service, and now veterans. With every patient encounter, the well-being of the patient in front of me is my primary concern. I am careful, thorough, and thoughtful. I treat my patients with love and compassion. My training taught a holistic approach. They taught it is my job to enhance the patient's experience of his life through improving their physical, mental, and psychosocial well-being. That's a big job. There's a lot to balance. It's not a straight line. It can be messy, but the end results speak for themselves. Patients treated in this way do very well in the long run. So I see them regularly. I get to know them, their medical problems, their other providers, their spouses, their children, their caretakers, even their emotional support animals. It's very difficult to put that all down on paper while it's happening. The act of recording interrupts the flow of the encounter. That's a balancing act. I did my very best to chart accurately and detailed to the point I and other providers would understand. I was staying late and coming in on weekends. I was doing my best. Obviously, I fell short. I failed to present a clearly readable record of what was actually happening. Time has passed. My typing has improved. My understanding of the electronic record has improved, as well as my understanding of the regulatory environment. I'm still not perfect, but I am reviewed regularly and never found to be deficient. I guess what I most want you to know is I am not a reckless, thoughtless, undertrained doctor. I am well-trained, competent, and compassionate. It's not an accident. No one was hurt. There was no diversion, and there was no abuse. That is the pattern of my career. Thank you.
All right, I'm now going to ask our panel members if they have any questions for counsel or Dr. Gruber, starting with our chair, Ms. Lubiano.
No questions on my end. Thank you.
Right, our vice chair, Dr. Hawkins.
Yes, so no questions, just a comment. As a physician,
So Dr. Hawkins,
yeah.
we have to limit it to questions.
Oh, that's interesting. Okay, all right. Thanks for your presentation.
All right, and any questions from Dr. Bullitt?
Yes, I do have a question for Dr. Gruber. So may I proceed, or does he need
You may
sworn in?
proceed, yes.
Oh, I'm sorry,
Yes,
I
you
wasn't
may
sure.
proceed. Yes.
Okay, great. Thank you very much, Your Honor. So Dr. Gruber, thank you for summing up your practice in your closing statement. And my question to you is, you mentioned the various places you've worked, and in particular, when this came to light, this two questions from you. One, in what you were doing, did you feel there was any scope creep of your practice of general primary care, family medicine in the setting you were practicing? That's my first question.
I'm not sure I understand the question.
Scope creep, meaning that were you doing things outside of what you felt you were trained to do?
No.
And my second question is, about regulation, you made that comment. And were you aware of the guidelines of the 2014 guidelines of the Medical Board of California regarding prescribing opiates at the time these things occurred?
I was aware of guidelines. That's a very general, broad question. I'm certain there's guidelines I wasn't aware of, and there was guidelines I was aware of, and I was aware that there were guidelines.
Thank you, Dr. Gruber. There's a lot of guidelines, I understand. So thank you very much.
Okay.
All right, Mr. Watkins, any questions for Counselor or Dr. Gruber?
Yes, I've got a few questions for Dr. Gruber. In the record, you testified you do not feel that toxic screening is valuable. After all of this, after everything that you've gone through, are you still of that same opinion?
Well, it's not that I don't think tox screening is valuable. I think it's less valuable than the other tools. The most important tool being the PDMP. After that comes your relationship with the patient, the community, the pharmacist. People who are diverters very easily learn to defeat drug screens. They know that if they get called in for a drug screen, they need to have the medication in their body. They take the medication before they go for their drug screen. They test positive. If they're engaged in large scale kinds of diversion activities, they aren't using other medications so that they don't come up positive. And there's only a 3-day window for most of them. So it's a blunt instrument. It has some value, but it's not as important as a lot of the other means that we use to supervise our patients. Regular visits, no early refills, no nighttime calling, no weekend calling. Make sure you come in for your appointments. These are methods that you use to find out who's squirrely, for lack of a better word, who's not acting normal among these people. And that's generally pretty easy to find out. And that's why when we look at these particular patients, they were found not to have opioid use disorder. They were on large quantities of medication, but that is not what opioid use disorder is. It is not abuse. And so, yes, I do think there is some value. To answer your question directly, I think there is some value, yes.
My second question is that you co-chaired this committee with Dr. Thorpe, the oversight committee. Is that correct?
Yes.
In one of the comments that Dr. Thorpe made, he was describing the difficulty of that environment, and that that it was almost like you had to kind of put it all together. I didn't surmise that it was it was people trying to put things together to make this work. I didn't find that there was like a whole guidelines basis for it.
Mr. Watkins, what is your question?
So my question is, I wanted to assess if that was correct. The environment was difficult that they were operating within. And that's why they had this oversight committee or, committee to review opioids.
Yes, that's absolutely correct. The community was overrun with opioid analgesics. And being rural and isolated, a few providers in the community managed to get many, many, many people on very high doses. Because this was a system-wide issue, the hospital created 2 committees to deal with prescribing practices and to establish for the practicing community how Adventist Health was going to manage these patients. And so it was starting at the beginning, building from the bottom up. Yes.
Okay, my next question is, Dr. Thorpe, he provided compelling testimony and he testified on your behalf in this case. And you also testified, you also mentioned on record that you knew he was sitting on various boards. Are you aware that he's also a current sitting
I'm
member
sorry.
on the medical?
Excuse me, you cut out there, sir.
Okay, I'll repeat.
Thank you. Thank you.
Okay, I'll start over. Dr. Thorpe provided compelling testimony on your behalf during the course of this case. And you indicated on the record that you knew he serves on various boards and things. Is that correct?
Yes.
Are you aware that he is a current sitting member on the Medical Board of California?
Yes.
And it didn't, what I'm concerned about with this, this case in particular, not so much the facts, was that a sitting member is engaged in the process. And we are encouraged to be outside of the process. And my question to you is, do you see that there's perhaps a glaring conflict of interest here?
Mr. Watkins, my concern is that that's outside of the scope of the evidence. It's the panel members are to consider. So you're limited to the evidence related to this particular matter. The issue of a conflict of interest, and to my knowledge, didn't come up in the hearing in this matter. Counsel can correct me if I'm wrong. So,
well, and that concludes my question. So thank you, Dr. Gruber.
All right. Are there any other questions from our panel members? No? All right. Matter submitted, Mr. Jerkowitz.
Thank you very much.
Yeah. Matter submitted, Mr. Yates.
Yes, Your Honor. Thank you for inviting me to speak.
All right. Matter is submitted and the record is closed. We are off the record.
Thank you.
Thank
All
you.
right. Thank you.
We should sign off now, right?
I'm going to turn this back to the chair, please.
Thank you. Yes, you may sign off as
Okay,
we are
thank you all.
moving to the next agenda item.
Ms. Lubiano, I've gone ahead and put them all back to attendee. They can stay if they'd like to.
Okay.
Please let me know when you're ready to proceed to closed session.
Excuse me, Your Honor.
Yes.
Do you need me to stay here?
I don't believe that we need you in closed session. No, thank you so much.
Okay, thank you, Your Honor.
If there is any information you need from her, though, Ms. Larson, or Judge Larson, this would be the time to get it. Like I'd usually ask her page counts and things like that, right?
I believe that the medical board arranged for the court reporter. Am I correct? Or I'm not sure. If the medical board arranged for it, then you get it from her. If we arranged for it, then I would get it from you, Ms. Temple. We'll go ahead and get it just to be safe.
It was the medical board, Your Honor. Yes, ma'am.
Okay, then all of that is done with the medical board then.
Great, thank you.
Thank you. All right, thank you, Ms. Temple. You're free to go.
Okay, and if the medical board needs anything, they can just email me, okay?
Thank
Thank
you.
you. Thank you.
Ms. Lubiano, if you're ready to head into the closed session, then the next agenda item, that second meeting is open for you guys to head over there, and then I'll go ahead and put up a meeting here, or a notice here that we're in closed session.
Yes, at this time we can move to closed session. See you there.
Thank you.
Hi, Sean, can you hear me okay?
Yes, can, Ms. Lubiano.
Okay, we're now returning to open session. Thank you for your patience. And the last agenda item is adjournment. I'd like to call the meeting to an end. Thank you.
Thank you, Ms. Lubiano. I'll stay here for a couple minutes, just let the joining board members know that you've adjourned officially as well. Thank you very much. Have a good one.
Thank you. Take care.